wealth and legacy plan, or a structured wealth and legacy plan, will help you or guide you when you have to make financial decisions. It's very important to take into account financial implications, tax implications, and also from that perspective the legal implications, because they're all integrated when you compile a financial plan. There's different steps that a person has to follow when you go through the financial plan. However, I believe the first step is to determine what your relationship status is. And there's very many reasons for that, because ultimately when you know what your relationship status is, that will determine what the value of your estate is. Because I've often found people to think that they've created this wealth and they're quite satisfied that this is going to be enough for them for retirement. And then when there's a maintenance claim or accrual claim, it obviously is not going to be the situation. So it's better to be able to know pre-hand what your value of your estate is and what the effect of your relationship is going to be if there is a claim. Since 1994, there are actually quite a number of relationships that a person can be in. This is an area where there have been many legal changes. You can either be in a civil marriage, or you could be in a civil union, or it could be a customary marriage. You could even be in a relationship which is regarded a religious marriage, or just in a living with another partner, which they call the domestic partnership. So there's really so many kinds of relationships that one can be in. In terms of the marriages, a person can select what kind of marriage regime has to apply to your marriage. Now, the most often what I find is people are married in community and property. That means that you do not enter into an agreement prior to your marriage, and by default you will be married in community, with the net effect that each party will own an undivided share of the joint estate. Now, often people don't realize the negative effects of this kind of marriage, but because they just don't find out before what the options are. The second kind of marriage regime that you find is out of community or property, and in this instance a person has to approach an attorney prior to your marriage, register that agreement, which is called the antenuptial contract, with the deeds office, and that will then result in each of you having a separate estate. It would also mean that each one of you would be liable for your separate claims or debt that you occurred during the marriage. Now, something that a person also needs to take cognizance of is the fact that if you do not specifically exclude the accrual system, it would apply to your marriage, and that means that at the dissolution of your marriage, each one of you will be entitled to half of the net effect of the estate. So a person has to take count of these kind of situations in order to plan around that, because if you don't know that you could have a claim against your estate, it could have severe impact on your financial plan. So there are obviously quite a number of benefits also for getting married out of community or property, and I find that not too many people make use of those benefits. For instance, if you tell your attorney that you wish to include in your antenuptial contract to provide for your children one day by life insurance, that means that the Estate Duty Act will allow you to deduct that amount for estate duty purpose, which I just believe is a wonderful opportunity, and very few people know about it and actually do that. What I also find, people marry out of community or property, especially if they're concerned about the fact that their estate would be used as security for business purposes, then you don't want to expose all your assets, and having two separate estates is much better than having or risking your joint estate. And also, in the event of death, if you have got a joint estate, the executor has to deal with the joint estate, not only with your half undivided share, which brings unnecessary cost, and also it could take months before the estate is wound up. Whereas if you've got two separate estates, you would be able just to carry on with your own estate, and you don't need to worry about a spouse's estate being wound up. Well, that's definitely going to determine in terms of what marriage regime you select. So if you're married in community properties, as I've explained, then it would be half of the joint estate. If you're married out of community or property, you would only have your own estate, and you can determine in your antenuptial contract at the time when you enter into marriage what the value or the starting value is, and whether the accrual has to apply or not. Then a person also needs to look at living together arrangements, because in many instances they don't have any agreements in place, and that just means that each person would have their own assets with no claim against one another, opposed to if you do have an agreement in place, that agreement would come into play and determine what assets you're entitled to. It's very difficult because to say which one is the best. I think some of them have got more benefits than others, but it will ultimately depend on the clients. And I just believe it's very important for anyone before entering into marriage to determine what the different options are, find out what the pros and the cons are, and then choose the one that suits you best, because then a person has had the opportunity, to plan around that specific regime. Currently, religious marriages are not regarded as legal marriages in South Africa, and therefore a person needs to deal with them as two separate individuals. The law does, however, protect people in religious marriages in some other acts. For instance, if you look at the interstate succession and also from a maintenance perspective, there are certain developments in law, but not in terms of the marriage, the property is concerned. That is something that I often find, is that people say we've been living together for 30 years, and then they believe because they've been together for such a long time that they actually are, regarded as being married in law. But that's not the case. In fact, those are the people that are more exposed, because they are not protected in most of the different laws in South Africa. So the option is rather to enter into an agreement with your partner to regulate the financial position in the event of a dissolution of this relationship. A lot of South Africans go overseas and get married. It would be deemed to be a valid marriage in South Africa, provided you've met the legal requirements and the formalities in the offshore country, and also provided that there's no rule in South Africa that makes that laws null and void. Then it will definitely be regarded as a valid marriage. There are other laws. If you, for instance, are not able, when the marriage dissolve, to claim because of the kind of marriage regime that you've selected, you would be able to claim in certain instances in terms of when your spouse dies for being Interstate Succession Act, or you could claim maintenance from that person. But it's often very difficult to prove the value of a maintenance claim. I think the most important thing is, if you're in a marriage or in a relationship, determine what the status is and how that's going to affect your financial plan. And if you're planning to enter into a marriage, make also sure, because you can choose the one that's going to be best suited for you.